Now the couples are not required to wait for 6 months for a mutual divorce petition. This is what the Supreme Court has held in the last week's Constitutional Bench judgment. Earlier the law was that if the parties are agreeing for a mutual divorce between them on the basis of their mutual understanding, or if they have decided that they don't want to continue the marriage and they want to live separately, then they can go to the family court, seek a divorce on the grounds of mutual divorce. And the law is that you will file a 13 petition, section 13(2)(b) petition is filed, and then the first motion statement will be recorded, and then second motion statement will be recorded after 6 months and before 18 months. That is the law that is done in Hindu Marriage Act cases and Indian Divorce Act cases, both. So they cover the entire population. Hindu Marriage Act covers the Hindu marriages and divorce in the Hindu Marriage Act. And Indian Divorce Act covers the divorce proceedings of all other religions. They may be non-Hindus or even Hindus registered under the Special Marriage Act can file for divorce under the Indian Divorce Act. Now there was a reference to the Supreme Court on the ground that if the court thinks that the marriage between the parties or the marriage between the husband and wife has broken down to the extent that they are not ready or they are not willing, or it is impossible for even for the court or the mediator or the counselor to patch the marriage and make them live jointly or rehabilitate the marriage. So under that circumstances, if the Supreme Court feels that there is a bitter fight between the parties, husband and wife, then Supreme Court can exercise its powers under Article 142 of the Constitution of India and pass a decree of divorce during pendency of proceedings before the Supreme Court. Initially, whenever such an occasion came, the Supreme Court asked the parties to go to the family court and then seek a divorce or seek a decision on their dispute. But now under this judgment, last week this judgment has been passed, Constitution Bench has held that if at any stage Supreme Court thinks and makes an assessment that parties are bitterly fighting with each other and it is not possible to rehabilitate their marriage, so exercising powers under 142 of the Constitution of India, court can dissolve the marriage of the parties. So that way there is a change, there is a change in the law, and this is to be exercised by the Supreme Court only. Another aspect which the Supreme Court has decided is that Supreme Court during pendency of any of the proceedings can come to a conclusion that this marriage is not going to survive. So Supreme Court can exercise its powers under Article 142 and pass a decree of divorce. It can be any transfer petition, it can be any appeal, it can be any other petition related to the marriage between the parties. So that way it is an attempt to end the bitter dispute of the parties and their fight and wastage of time, money and energy before the courts. So that way this judgment is a landmark judgment, and now the parties who are before the Supreme Court need not be required to wait for 6 months, and their marriage can be dissolved by the Supreme Court under orders of Article 142. Otherwise the law remains the same. If there is a fight between the parties and if they have mutually agreed and approach the family court within 1 or 2 years of their marriage, then the cooling off period will automatically apply. It is the law, it will remain there, it has not been waived off. There should not be any confusion, and the media reports in this regard are also not very clear. So we get queries day in and day out that I want to get my marriage dissolved within 1 day. It's not possible. If there is not a delay, if there is no bitter fight, if the husband and wife within 1 year or maybe 2 years or 3 years of their marriage decide to part with, then the cooling off period clause will remain. It is there. Supreme Court has not changed it. So that process will be followed. So what Supreme Court has done is that if the Supreme Court sees that there is such a bitter dispute between the parties and it is pending since last more than 6 years, and parties are living separately since last 6 years, so there is no chance of their revival or reconciliation between the parties, so Supreme Court can exercise its powers under 142. There are other aspects of the matter which the court has laid down in the judgment, which are related to the maintenance, the status of the children, or other factors depending upon the facts of the case. So that way we see that there is a big change in the law, and the Supreme Court has powers under Article 142 to dissolve your marriage if any proceedings are pending before the Supreme Court and Supreme Court thinks that this marriage is not going to survive, so they can pass a decree or a judgment and dissolve your marriage on the basis of the proceedings, and they can also close all other proceedings, quash other FIRs, and do everything in this regard. So that way this process has been simplified by the Supreme Court now. Otherwise what used to happen is that party used to have disputes between them and various litigations pending before different courts, some litigation pending before the family court, some litigation pending before the domestic violence court, some litigation pending before the police, some litigation pending before the civil court. So it used to take several months or even years in getting those matters settled, even if the parties used to take mutual divorce after their settlement. So that way this is a very good development, and now the Supreme Court can come to a conclusion that this marriage is not going to survive, and they can pass a decree dissolving your marriage and even quashing all other proceedings or setting aside all other proceedings, closing all proceedings. So that way it's a good development, and hopefully the couples who are fighting their bitter fight before the courts above High Court or up to the Supreme Court will get some relief in this matter.